Can we any longer trust our judges? This is a really important question following the appeal court's ruling on the Bell Hotel in Epping. What happened was that the High Court said that the Bell Hotel should be closed, that the migrants should be moved out, an injunction was granted, whilst the whole case was going to be heard at a later date. The appeal court stepped in and, in a ruling that is fundamentally helpful to the government, has ruled that the High Court was wrong. Does this matter? Yes, because it has taken away a headache for the government, and the government argued in front of the appeal court that the rights of the illegal migrants took priority over the rights of residents. They actually said that. That was the case that they made, and the appeal court agreed. Now, in normal circumstances, judgments aren't questioned in this country. We have confidence in our judiciary to behave fairly and properly. But in this case, there is a major question, and the question is in the form of Lord Justice Bean. Because Lord Justice Bean, who is a senior appeal court judge, a distinguished legal figure, is also someone who has had a long-standing association with the Labour Party. What is this association? Well, he was a member for many years. Fair enough. I wouldn't make any criticism of that. Lots of people belong to political parties. It's a good thing to do. And that's a minor thing that it's probably pretty easy to put aside when you're making a judgment. But much more importantly, he was the chairman of the Fabian Society. Now, what is the Fabian Society? The Fabian Society claims to be the oldest think tank in the country, but it's also one of the foundational pillars of the Labour Party. It is instrumental in the Labour Party's existence, in its formulation of policy, and in its belief in social democracy. Crucially, and to their great credit, the Fabians always believed in democratic socialism rather than enforced and imposed socialism. And Bean was their chairman. Again, you may say, well, nice honorific post, does it matter? Well, yes, it does, because the chairman of the Fabian Society is not some minor figure, is not some junior chap who's asked to help out for a year. It is a post often held by the great and the good in the Labour Party, or those who are going on to be the great and the good within the Labour Party. So the year before Bean had it, it was Brian Gould. Brian Gould was one of the architects of New Labour, very important figure in advising Tony Blair, crucial to Labour's development in the 1990s and its ability to win a majority of such a scale in 1997. It was followed by Robin Cook, another of the central pillars of the Blair regime, somebody who became Foreign Secretary and then, as it happens, resigned over the Second Iraq War. So he is sandwiched by two people high up in the hierarchy of New Labour. Other figures subsequently are people like Ed Balls, major players in the New Labour regime. Ed Miliband was a member of the Fabian Society, and of course, as I mentioned, Sir Keir Starmer is the first Labour Prime Minister who is an active Fabian. So a judge who is instrumental to the decision is a member of, or was, to be more accurate, a member of and chairman of a society which the Prime Minister is a member that has made a decision that is enormously helpful to the government. Gets it out of a terrible hole. It had no idea where to put these people, and it was worried that the same would happen across the country. The appeal court judgment helps the government, and one of the figures in it is somebody who is closely associated with the Labour Party at a senior level. Now, this is a problem. And the reason it's a problem is that our constitution has changed in recent decades. If you go back to the pre-1972 position, prior to the 1972 European Communities Act, the courts had one simple job, and that was to say what the law meant. They didn't have to say what the law ought to mean. It was just, what is the law? What has Parliament passed? Now, they've taken on a different role. They not only say what the law means, but what it is allowed to mean. What do I imply by that? Well, if you look at the European Communities Act effect, It meant that the courts were able to strike down acts of parliament. They were able to say that the European Communities Act is senior legislation, and therefore this junior legislation can't apply. This was all invented by the courts. There's no statute that gave them the power to do that. They just decided to do it. And realistically, our membership of the EU would have made no sense without that understanding of the seniority of EU law. But you'll be saying to me, we've left the EU, so surely this doesn't matter. But there are other acts that have the same effect, one of which, of course, is the Human Rights Act. The Human Rights Act doesn't ask judges to say what the law is, it asks them to say what the law ought to be, an essentially political decision, a decision that requires not your legal understanding, not your studying of rare text, not the black letter of the law, but what you think rights mean and ought to be and how they should be applied in a legislative context. What does the Human Rights Act allow judges to do? Well, two things. One is to interpret the law as far as possible in accordance with the Human Rights Act, and therefore to try and avoid a conflict by essentially a Humpty Dumpty approach to language, to say, well, the law means this, which is in accordance with it, rather than what any normal reading of the words might suggest. The other thing is to issue a certificate of incompatibility to say that Parliament's got it wrong and must think again. And so far, whenever our courts have issued a certificate of incompatibility, Parliament has responded by changing the law. There's an accelerated process by statutory instrument of changing the law if the judges issue a certificate of incompatibility. So this has changed the relationship between the judges, the government, and the legislature. Historically, we had a really very simple system. Our whole structure of administration was the king in Parliament. The king, the crown, his ministers, all of them members of Parliament in the legislature, in either the Lords or the Commons, and the judges, the king's judges, are linked both to the king and to Parliament, a committee of the House of Lords. That was our structure. Parliament was everything. The king in Parliament was everything. There was no separation of powers. There was no suggestion that the judges were able to override the legislature, and they were very cautious about overriding the executive as well. That's changed with the creation of a Supreme Court and with the acts that have allowed judges to decide what laws ought to be in principle rather than what they are in fact. Now, this brings the political opinions of the judges into question, into legitimate political question, because the decisions they're making are fundamentally political. Look at the Baroness Hale decision on prorogation. That was an ultimately political decision, essentially a Remainer decision against a Brexiteer Prime Minister. I note that Baroness Hale, once in the House of Lords, back in the House of Lords after her period as a judge, consistently voted against Rishi Sunak's immigration policies. Gives you an idea of where her politics were and underlines, to my mind, how decision making started to be made, that they were given the power to make political decisions from our membership of the European Union. They began to do that, and that has made their politics of legitimate interest. In America, they get over this problem by having public hearings. They find out what the judges think, what they believe, what their politics are, and then the Senate can decide whether to appoint the judge recommended by the president or not. We haven't done that because historically the judges' politics just didn't matter. When you were determining what the precise wording meant, politics doesn't apply. It goes out of the window. It's a routine, functionary matter. Now, because of the Human Rights Act, we are allowing judges to decide what things ought to be. So their politics are of interest. Being, as former chairman of the Fabian Society, sandwiched, as I said, between two luminaries of New Labour, ought to have seen this was an obvious conflict. He should have recused himself. And if there are Conservative judges in similar circumstances, they should recuse themselves too. We cannot have a politicised judiciary. Actually, my solution would be to return to the House of Lords, scrap the Human Rights Act, go back to the status quo ante, a proper Tory approach. But until we have that, the judges are on notice that their politics are of interest. And if their politics are supportive to the government and they make decisions that get the government out of a hole, people like me will ask questions and will say that the judges should not sit on those cases. They should allow their fellow judges who do not or have not nailed their political colours to the mast to make the decisions instead. Because trust in the judiciary is fundamental to the rule of law, and this decision will undermine that very precious, important, crucial trust.